on my recent appointment. I got some really heartfelt greetings and well wishes that practically brought me to tears. And I really appreciate that persons seem to hold me in such high regard. I have had King's Counsel, Mrs. Kitson before me with Mr. Alan Wood, King's Counsel, and other counsel in July at the end of the term. And there are others, like in the Sean Campbell case, who extended their congratulations. I sincerely appreciate your good wishes, and I hope I'll do all that I can to make you proud and not embarrassed by your confidence, by the confidence you seem to repose in me. With that said, the Court of Appeal has implemented its strategic plan that is aligned with the broader strategic plan of the Judiciary of Jamaica. The Judiciary had launched its plans earlier in the year, and this has allowed the court to tangibly and measurably work towards the achievement of the overall mission and vision of the judiciary. When we look at the plan, there are different tiers, tier one, tier two, tier three. The focus at this point in time for the court, having gone through establishing our plans in keeping with tier one and tier two, is to focus on the tier three level of the plan. And simply put, this aspect of the plan is to put the individuals, put persons, people into the plan for the advancement of the court. And this means that each individual and team in the Court of Appeal should understand their role and be motivated to achieve their objectives as part of the group effort to achieve the overall objectives of the court and, by extension, the judiciary. What this really means is that we are going to a micro level of judicial management where each person in the court is expected to have a plan, a personal plan as to how you expect to perform your duties and to measure your output. This will incorporate, of course, the general management scheme proposed by the public sector through the employment performance management system, which is a totally new system for management in the public sector. So what this means in essence is that everything is performance driven, performance centric, and performance oriented, and at the end of the day, each person will be assessed on their performance. To the best of my understanding, this is tied to increments. That means if you don't perform in keeping with the target set by your immediate supervisor and the organization, then your increment might suffer. And for those who meet the targets, there will be incentives, I'm told. So it is really moving towards performance as the measurement for our output. So the court is committed to focusing on each person's individual plan, as we believe that by nurturing and supporting each individual, we can collectively achieve the judiciary's objectives. The focus on the individuals, of course, will bring to the fore other initiatives that we have taken from the tier two project. So the individual role in differentiated case management and backlog reduction will be assessed, evaluated, and measured. And this initiative is in support of improving external stakeholder satisfaction. The e-filing project initiative in support of the objectives of improved technological resources and infrastructure will also be on the table, and we will seek to improve our data management and internal processes. Just to say that a part of this is our thrust or our plans to be certified as a court of excellence through the International Standards Organization, Standards of Organization or Organization of Standards, sorry, program, where our management methods and our processes and procedures will be evaluated to see if they meet international standards. So by this means, we have consultants with us right now who are interviewing the persons involved, especially in the registry, to recognize our gap deficits and to see how we can better able to strengthen our systems to make our court better serve its stakeholders, especially our external stakeholders. Stakeholders. So this should operate more to bring a more efficient court of appeal to the public, and we should be able to achieve our top level objective of improving external stakeholder satisfaction. Now, I won't go into statistics. I really don't like statistics. Um, I'm not good at statistics. As I see numbers, I freeze. I prefer the story that it tells, and therefore I prefer to drill behind the statistics because statistics don't really show the true picture at all times. So, if you're interested in the performance of the court as documented, I would recommend that you read the court annual report that was published and I think circulated among key stakeholders. I doubt any of you have read it because we hate to read, but it really documents everything that will show how the court is performing. And we are described as a high performing court. And that is why we have been chosen by the Chief Justice with other courts, the Gun Court, and I think a parish court, Hanover Parish Court, to lead the way in certification for court excellence. So, one area that I know you might find a bit controversial is how we are, what the statistics show to be the rate of our judgment delivery. That is a sore point. It's a sore point for us at the court, as I know it is a sore point for our external stakeholders. Somehow, we have not been able to get that magic to have no reserve judgment analyst. I Even the best of the best came to the Court of Appeal and retired, and they did not manage to bell that cat. Is that the proper proverb? I'm not sure. But it has run away from us no matter how hard we try. The statistics will show that we are, in terms of our judgment delivery, we are way above the international standards. The international standards is 100%, and we are measured to be over 300 and something percent in 2023 and 449% in 2022. But you're not feeling it because you're awaiting your judgments and you're awaiting your judgments for a while. So I am not comforted by the statistics, despite the fact that we seem to be doing well in that area. We had our judicial retreat last week, and that is an area that we have highlighted and isolated for focus during this term. When I acted in 2022, what I did was to give each judge a target. And I was of the view that if we each try to reach 5 cases, if there are 13 of us, we should be able to reduce the list by 65 cases, which would mean bringing us way, way down. We managed to do it then, and that is why our figure showed 449%. That is what we're aiming to do this term. But bear in mind, this is a very short term. So I don't know, but we believe if we set it at 5 per judge, if we fall at, say, 3, we'd still be in an area that is acceptable. So this is one of our biggest challenges, I must tell you, and that is the failure to give timely judgment in all cases. We're all guilty of it because it depends on the complexity of the cases, and it also depends on what cases we have to deal with during the term. Last term, despite trying to get rid of older cases, we had to put them aside to address cases where persons' liberty would have been at stake in the criminal realm. And there was a civil case that involves someone whose destiny, I would put it, needs to, or status needs to be set resolved in a very short order. So we sometimes we have to put aside judgments we are working on to deal with those that we would call, I would say, I hijack the system. So please bear with us. While our judgment delivery standard is above international standards, we are still not comfortable, and we will be working assiduously to reduce the backlog of reserved judgments. During the retreat, we have set standards, time standards for ourselves for the delivery of judgments in accordance with international practice. And we acknowledge it will take a lot of work to bring ourselves up to date, but it is a task we are prepared to undertake. And we are committed to this undertaking with zeal and determination. We have also identified some issues that will warrant the sitting of a full court at some point during the term. There are issues pertaining to certain legislation, and I think we can highlight the Firearms Act. The Firearms Act is giving problems to prosecutors, it's giving problems to the trial judges, and surely at the Court of Appeal, we might have seen other cases where the court might seem inconsistent in its approach, and we have taken the decision that we have to take steps to put the court in a position where we can declare conclusively what the position of the court is on a particular area of the law, so to avoid confusion. So sometime I have a case to case manage today which will deal with a particular area, treating with whether we should give credit for time served even if it goes below the minimum set parliament's minimum sentence. That is a constitutional question, and the court is looking forward to resolving that one. So that is how we propose to deal with difficult areas. We empanel a court of no less than perhaps nine, given that seven, let me say, given that it's a court of 13 persons. The next thing that I would highlight, I'll soon be finished. It was not as long as my judgments, Mr. Equiano, is the temporary occupation of the judges of counsel's room. I think this was brought to my attention last week that personnel from the bar came to have been in meetings with us about counsel's room. We had a room for counsel but over the what we call the older section. That is where the Court of Appeal is coming from. But due to circumstances beyond our control as a result of Hurricane Beryl, the Court Administration Division is given temporary, is given a license to occupy that section of the of the building because they are not tenants, not even at will. So we don't want them to think they have exclusive possession. We have a right to go over there when we want to. But be that as it may, they are using that section. So we have two rooms out there called meeting. On the door, you'd see meeting rooms. Unfortunately, they don't have their ensuite rest room area. So for the council, we are giving you use of one of those rooms, but unfortunately for now, and I hope it will not be for too long, you will have to use the rest area designated for the public. But happily, there's not much public members of the public coming to the Court of Appeal, so it will be like it's yours until the Court of Appeal leaves. So I hope that is until the CAD leaves. Thank you. That is comfortable for you for the time being. As I said, the court has decided on several initiatives, and one of them, this is really not for counsel, but it is because it would free up time for counsel, cases in which counsel would be involved, and that is an intention for us to develop a self-represented litigant protocol. I've identified a team to assist us with that, and what that will do is to strengthen our our processes and procedures so that the court will be more efficient in disposing of cases. Because when we have litigants who are not represented, it really sets us back. They don't know what to do well. The court has to spend time trying to explain to them, and that takes time. So we have looked at a model from New Zealand, which seems quite attractive, but we have designated team members to just look all over the world to benchmark the best practices that we can adopt. So this is an initiative that we will be undertaking, and we again welcome any suggestions. We will have suggestion boxes at strategic points in the court building, including the registry, where counsel can send your own little note, drop in if you want, or you email us with your suggestions. We welcome anything that can assist us to meet our targets and our objectives and to serve you better. Just to highlight too that rather than having counsel on radio or in the media speaking about matters affecting the bar or the legal profession, we would prefer if you use the court users committee channel. We have set up a court users committee. This was set up under the aegis of the late Justice Dennis Morrison, King's Counsel. May his soul rest in peace. And the aim is for us to have a space in which we can discuss all matters pertinent to the use of the Court of Appeal. We have taken the time out to let you select your own representatives on that committee, and we sit every other month. This is bi-monthly, and when we go, we call upon the representatives of the stakeholders to tell us what your concerns are, what your growths are, and we expect that during those meetings, whatever issue you have will be brought to light and ventilated, and the court seeks to address them. I would hate to hear, although I've not heard anybody quarrel about the Court of Appeal in the media, but I wouldn't want to hear that because we have provided a space where we can talk and frankly with each other about your concerns. So this is just to say, please, I'm urging counsel to ensure that you use the appropriate channel established by the Court of Appeal to communicate your concerns, proposals, and recommendations. We welcome anything once we believe that it is legal, workable, suitable. And the last thing, I don't want to bore you much more, everything else will come out in the wash somewhere down the line, is, just to say, another initiative, our docket system will continue. At the end of the year, we'll evaluate its impact on the disposal rate to know if we should adopt it. And that is really one panel sitting for the entire term dealing with cases. So artificial intelligence investigation, the Chief Justice is very much into technology and innovative ways of adjudication, and he brought it to the fore that he believes that the Court of Appeal could benefit somehow from the introduction of artificial intelligence. My view has been and will always be that we don't jump in unless we know what we're jumping into. So we have set up a team now to look at the ethical considerations, especially not only the efficacy, but the ethical considerations that should govern the use of artificial intelligence. I tried to see how it works. I cannot vouch for its accuracy. It gives me information that is not accurate. And I hate when it gives me suggestions and I adopt those suggestions, that when I do my AI and plagiarism check, which I do in my own documents, it is telling me that how much percentage of my work is showing AI pattern. Because what that is telling me is as if I have no almost half of my work is not my input. So it really raises questions as to when persons give you their opinion, give you their judgments, how much of it is really coming from their brain. I don't want to replace my brain. I'm sorry. So, and we need to appreciate what is the standard for plagiarism every academic board will tell you how much percentage is acceptable. So the court must know how much percentage of the application of AI would be acceptable as a standard. There are different disciplines with different standards. So we need to appreciate what is the standard for the legal profession and the judiciary. And the worst part of it is that while they're saying you can use it for something, but you can't use it for something, when you have your entire work, the AI doesn't tell you which part of it is AI attributed. So these are issues that we have to deal with. And the last thing, which is my most exciting initiative, or the court's most exciting initiative, and I hope the judges, we had our retreat and this came out of our retreat last week. And it has to do with our wellness initiative. That is to incorporate wellness in the court's proceedings, in the sense that we must focus on our health. Judges, lawyers, everybody. We learned that sitting down kills you more than death itself. And our job is predominantly a sitting down job. When we come in here, we're sitting from 9:30 to 11:30. That's 2 hours. I have to ignore my watch telling me time to stand. But we think we need to stop it because we're killing ourselves slowly without movement. So we had invited a wellness, health, physical therapies expert from the Ministry of Health and Wellness, and he was here with us last Friday, as well as a psychologist. And we went through the whole issue of stress management, mindfulness, and all that, and physical wellness. And when we were finished, we were sold on the idea that we need to move more. And we need to introduce movement within our court. And we thank Mr. Trevon Morris for that, because he taught us how we can stay right where we are and do exercises to help us. So this is what it boils down to, counsel. After 1 hour, it is suggested, I can't tell every panel what to do, it's a matter for the leader of the panel, but we would put in as part of our regimen we break after 1 hour of sitting for between 5 to 10, and I think they say 10 is the minimum, just for movement. The judges might revert to outside and they're gonna do their movements based on video-led videos. We are saying, and this is a suggestion, and you can give me your feedback. I see Mr. Kelly seeming very interested, but we can put the video on our screen there, and you move. We're not gonna use things that could affect your heart if you have a heart condition. It's just basic stretches that, even if you have a heart condition, could be beneficial to you. So we want the Court of Appeal to lead the way in this innovative way of adjudication, where we incorporate wellness and our well-being into our work, because we appreciate that when it's all over, the work is gone. We are only left with ourselves, and the work is going to wreck us if we don't take time out to self-care and self-love. So this is to ask counsel. When you hear the court say we have to rise at 10:30, this is our health break. It means what it means. We are going to go wherever. If it wouldn't look bad, we could even ask you to join us here and we stretch, but we will look into that. Or if counsel prefer, we leave you and you stretch on your own by video-led exercises, and you do what you have to do. And when we all come back in, we take a deep breath and we go on again. I don't know if Mr. Taylor seems as if he'd resist that. But even deep breathing, they taught us how to deep breathe, because how we breathe in with our chest in is not the right way. We must breathe in and our tummy must expand outward. And when you let out that breath, it goes in and it gives the oxygen to your brain, and you're sharper and more focused. So, Court of Appeal will lead the way in the Ministry of Health and Wellness's movement, whatever they call it. I'm not sure of the forensic term, but I'm sure it will make us feel much better. So I don't think I have much more to say because I'm taking too much time, but that is what I'd want to end on. What I believe is a high note for incorporating the need to ensure our personal well being within the work space. We will take, I'm not sure if we'll take our usual 30 minutes coffee break, what we used to call a coffee break, if we're going to take 10 minutes for health break, but that's a matter we'll determine. But the worst case, the best case for us really is to say 10 minutes health, 20 minutes coffee, and then by 1 o'clock we are finished. So we would have incorporated movement within the time. So we are open to any suggestions, ideas that you have in that regard. So as we approach the end of the year and the last term of the year, oh, one other thing, we will be doing our outreach as well. We continue our outreach programs. We have been inviting high school students and so on, but this we have been invited by the correctional services to explain to them the appeal process because I think they are the ones who have to file appeals on behalf of the convicted person. So we will be dealing with the correctional services and we'll also be bringing the Court of Appeal out to the parish courts to start with because we find that there are issues with the filing of appeals from those courts. So the outreach continues. So I would ask, of course, for your usual cooperation and understanding. And you must appreciate that we have our limitations. Some are beyond our control. That means we have no control over them, like procurement processes to get an air condition unit for the registry. So we're in the heat, but those are beyond our control. But those that are within our control, we will aim to improve, enhance, and strengthen as time progresses. So, though I may consider the future with a measure of anxiety, knowing my limitations, I look to it with a countervailing measure of enthusiasm, optimism, and hope, knowing where my strength lies as president of this court, and that is hugely in the support and cooperation of the valued team at the Court of Appeal. Without them, I am nothing. I also entertain a sense of assurance that I'll be greatly assisted in achieving our objectives by the customary cooperation of the private and public bar and counsel from all sides. I can only hope that this belief that I can rely on your cooperation is not misplaced. So it leaves me to wish for everyone a prosperous, first, safe, healthy, and productive and enjoyable Michaelmas term. Thank you very much. We're open to any comments, any talk this time.
My Lady President of this court, judges of this court, Supreme Court and parish courts, perhaps virtually, those serving and retired, my learned friends, I am delighted to bring you greetings on behalf of the General Legal Counsel. At the commencement of this Michaelmas term 2024, today, my lady, for the first time in judicial history in Jamaica, a time-honored tradition, though not in this court, commences with a lady. You, my lady, at the helm of this court. I deem it a truly signal moment, and as you follow in the footsteps of our former Chief Justice, not the same, but similar. My lady, notwithstanding the changing scenes of life, economic, social, political, we continue to be blessed by a cohort of excellent judges who have upheld and built on the long-standing precedents of sterling jurisprudence, thus advancing the trust and confidence of our people in the judicial system, which benefits us all. I welcome your indication of the intention of this court to establish e-filing, data management in the court, and of course, the effort to improve the timely delivery of judgments. I hope that the same can be entrenched soon. My lady. And so those of us who have dedicated our professional lives to, whether at the private or the public bar, those of us commit to creating a fraternity focused on ensuring that we are diligently and creatively pursuing justice and peace, the watchwords for this legal year. And so, my lady, as the year succeeds last year, I salute you and the members of your court as you indeed chart a new, though not different course of delivering justice to all. May it so please you, my lady.
Thank you.
My lords.
Thank you. So Taylor.
And permit me, I do not increase the size of the font. And permit me to read from my remarks instead of just speaking.
So any way you want to do it, Mr. David.
Yes, my lady. May it so please you, Madam President, learned honorable members of this court, members of the bar, King's Counsel, head of the GLC. Allow me to express first my personal and also the official compliments and commendation to you, Madam President,
Thanks.
on your well-deserved appointment and elevation to be the head of the Court of Appeal. The issues facing the Court of Appeal in this term and also from preceding terms seem to be universal throughout the Jamaican system. But there are still some things that have remained consistent. I have heard my lady's viewpoints on the rate of disposal. But my lady, the rate notwithstanding, we know that the Court of Appeal continues to deliver high quality of justice, delivering well-reasoned judgments while carrying out your role of hearing litigants, reviewing decisions from other courts, affirming or reversing those decisions, or proclaiming, clarifying, and explaining the law. We know that there are some issues, and especially from our office, we have noted the numerous submissions on post-conviction delays. And I must express, my lady, it is kind of hard for us as a prosecution service, having fought a case hard, having what we thought was a good sentence, a good summing up, to come and meet a ground that we have had nothing to do with, and it is hard to resist. So we hope that will be addressed, especially embracing of technology, and trial transcripts from the circuit courts, and especially notes of evidence from the parish courts will reach here in a timely fashion. My lady, we are also mindful of the need to embrace new technologies to make the work of the court more efficient, although I too share your skepticism about, well, cautious skepticism about artificial intelligence. I have recently read 2 judgments, one out of South Africa, one out of the United States, where artificial intelligence invented case law with citations and all of that. So It is something to, these are waters that we must tread and swim in carefully. And although the backlog has to be dealt with, and here's where I make my wellness pitch, we think a reasonable number of cases ought to be set to be heard for the week. It's probably more for the registry than here. So we find that 3 will work for our chambers, but when you start to set 5 and 6, it really puts a lot of pressure on Crown Counsel who has to read all 6 transcripts versus counsel who only comes with only 1. So that is my wellness initiative that I am proposing. I hear my lady on wellness. I am cognizantly aware that I'm physically fat and not physically fit. But I do not know if I am willing to stretch in front of my more life and limber colleagues. The ODPP, my lady, is mindful of all the issues here. And
you can stretch outside, you don't have to be before them. It's just you taking your health break.
My lady, I don't want to see anything appearing on social media. The ODPP is mindful of all the issues here, and as usual, we pledge our cooperation to work out these issues, especially through the Court of Appeal User Group and the Criminal Case Management Committee. The ODPP wishes the Court of Appeal a very productive term.
Thank you very much.
May it please you, my lady.
You can dress for me a little.
Yes. Thank you very much. Seem to have been falling apart.
Yeah, he must smile.
May it please you,
Thank you.
my lady. Judges of the court. I wish, on behalf of the Advocates Association of Jamaica, to extend our heartiest congratulations on your appointment as President of the Court. It is a well-deserved one, and I echo the sentiments of the membership that it is very well-deserved. We pledge our support to the initiatives. We know that on the face of it, the numbers are daunting. The cases, it would seem, on the face of it, are in the solution seems far away from us. And we seem merely to be doing as best as we can. At the end of the day, it is the purpose to seek to serve a public in need of probably what is the most valuable service that a nation requires: justice. I think with cooperation from our Advocates Association, we will look at these new initiatives, we will think of them, and we will do our best to participate. My lady, sometimes you hear comments on the media. I think if you heard from a certain gentleman who is seeking to be president elsewhere, he seems to be of the view that if comments are not made publicly, no attention will be given to it at all. But we do our best to listen and to participate and to cooperate in this process. We don't run there as a first option. But you do appreciate, my lady, that we as representatives of the public, we are under great pressure. And only with the cooperation from us, judges, registry, we can achieve what they ultimately desire, to have a just outcome at the earliest possible occasion. I wish you all the best, and I wish the court all the best in its endeavors as we proceed throughout this term. May it please you, my lady.
Thank you so much, Mr. Green. You're always with us, although you're not poor.
No.
My lady president, my lords, my lady Madam Justice Straw, might it so please you, I represent the president and counsel of the Jamaican Bar Association this morning and apologize on behalf of our president, Mr. Kevin Powell, who is unavoidably absent, and also apologize on behalf of Mr. Michael Hemmings, President of the Cornwall Bar Association, who has asked me to tender his apologies. He's currently commuting. First, the milady, I'd like to indicate my greeting will be as short as the Michaelmas term. We celebrate with her ladyship on her ascension to being the first female president of the Court of Appeal, and milady wish her ladyship and the court all the very best for the term. Objective 4 of JAMBAR's or Jamaican Bar Association's objectives indicates that we are to offer service to our system of justice and those in need of aid and protection. And so, through the support and collaboration with key stakeholders in the justice system, the Jamaican Bar Association commits the same, and that includes the Court of Appeal. And so we commit to our usual collaboration through our representatives on the Court of Appeal Users Committee to share, as her ladyship has indicated, any views, recommendations, and suggestions for our satisfactory use and service delivery to all. We are also very intrigued and very, open quotes, mindful, close quote, of the plans for the Court of Appeal this term and wish for the Court of Appeal a most productive Michaelmas term. Might it so please you.
Thank you so very much, Mr. Keller. I think that brings us to the end of the formal proceedings for this morning. I am here as a trespasser because I'll have to hand over to Justice Williams as the head of the panel with him and Justices Straw and Brown. So again, I cannot thank you enough. When I saw the rain this morning, I figured we would have had empty benches. So for you to be here, we truly and sincerely appreciate it. Those who do not have any business in the court, as I've said before, you could have easily been elsewhere. But we thank you for your cooperation and the respect you show to the Court of Appeal. So have a wonderful day and a more enjoyable and safe and healthy term. And we'll see each other during the Christmas season. So we're going to rise now to allow me to depart and for the court to commence officially. Thank you very much.
Yeah, that's nice.
In Congress, I helped pass bipartisan laws to lower the cost of prescription drugs, took guns out of the hands of violent offenders, made historic investments in veterans' healthcare, and created thousands of manufacturing jobs here in Central Florida.
I'm Darren Soto, and I approve this message.
With Frontier Fiber Internet and YouTube TV, I'm thrilling to 100+ channels of live TV starting at $95 a month on one simple bill.
Switch now to 100% fiber internet and cable-free live TV.
Good to have you with us on a busy Monday morning. I'm Joe Fryer.
And I'm Savannah Sellers. Hope you had a great weekend. We're glad you're here. We begin this morning with a new NBC News poll. It shows Vice President Kamala Harris leading former President Donald Trump. With just over 6 weeks until Election Day, the poll finds Harris with a 5-point lead among registered voters. It's important to note that's within the margin of error, but does mark a shift since July's poll, which had Trump ahead by